Welcome to the REeBroker Group Virtual Realtor Training Opportunity for September 2022. I'm Kathy San Marcos, the Director of Operations. So if you're not currently an MLO and you are interested in getting your license, we do have information on our website. Here's the URL. I'll just share my experience years ago when I got my license. It took me about $1,000 and it was about a 3-month process. But once I started doing loans, there's a lot to learn. So, if you have another job or what, you need to really make sure that you have the time to allocate to processing loans because of the fact that there's a lot involved. You can, once you take the application, you can hire a processor. Once your loan is placed with the lender, you can hire a processor to take over. I did that, but I still, you still have to be hands-on because I found that those processors, they don't work on certain days or what. There's time constraints you have to meet because just to meet the guidelines for TRID and all of that. So really do your research. If you are interested in it, you can reach out to me or Paige here at our office. We're both happy to help you. All right, next. Okay, so this one, Sarah, do you want to take this?
Yes. Okay. So we just wanted to touch base a little bit about when to issue an acting against brokers advice. So if you're representing sellers, you will want to, so for seller clients, the pre-printed language addresses the following and other items can be added. So on an acting against brokers advice, this is what will be listed. If something comes up in your transaction that you feel is kind of skewing against what you would advise your seller, but they're wanting to move forward, always issue that acting against brokers advice, write it in whatever that scenario is, just so that you are protected, that you advise them against this. So, making failure to make agreed upon repairs, refusing to permit agreed upon inspections, allowing the buyer to move into the property prior to the close of escrow, allowing the buyer to make repairs or renovations prior to the close of escrow. And then on the flip side, if you are representing the buyers, here's some of the pre-printed language that addresses issues that are common. Making offers with no or limited contingencies. We definitely don't recommend that. Removing contingencies early or without the required disclosures from the seller, failing to investigate the property. We definitely don't want them to go into it with no inspections, closing escrow without receiving reports or disclosures, making multiple offers with the intent or ability to only follow through with one, making an offer with an escalation clause or promising to pay a certain amount more than any other offer received. So all of these are scenarios, common scenarios that we and CAR have seen that goes against what we would recommend. So if any of these scenarios your clients want to do any of these listed, we suggest that you issue the acting against brokers advice, which can be found in the Zip Forms library for CAR docs. And the link is there too if you want more information about, again, acting against brokers advice. Next.
Thank you. On those documents, make sure you choose all or sample library. There's a lot of good forms in sample library too. When you're having issues with your transaction, that they'll help you out. If you're not sure, reach out to us and we'll help you with that. Okay, next thing we want to talk about is MLS cancellation. If you need your broker to cancel, you need to notify us. And so the date signed on the cancellation or cancellation of contract should be the same date that the MLS cancellation request is submitted. It's to avoid any confusion and to any violation for Anthony the broker and yourself. We're seeing $250, $500 fines for those MLS issues. If you know that your transaction is not going to close by the date that you have listed in the MLS, make sure you update that prior, because this morning we're dealing with one where it was a day after. So you may not think it's a big deal, but $250 is a lot of money to pay just for missing that deadline for the MLS. So, and we're not imposing the fines, it's the MLS doing that. Next. Okay, so here we had the, if you want to look there's MLS listings or CMLS, whatever your particular MLS is, really get familiar with your guidelines there so that you're in compliance with those, because it's not a fun process to have to deal with trying to get it, what's it called, the word they use, Sarah, can you think of the word that's like when you're debating that you were out of compliance, because we don't see many of the violations waived.
Yeah, when you like dispute it, yeah, we don't see that they are very accommodating.
Right. Yeah, very good. Okay, so remember, all changes on the MLS must be made within 2 business days of receiving a request from the seller so that the listing data is current as possible. Okay, I would really check with your MLS. Those are CRMLS rules, but if you're not CRMLS, you'd want to check to make sure. So next. Okay, so Sarah, take it away.
Okay. So I just wanted to talk a little bit about home hardening. There is a new disclosure requirement that came out January of 2021. So here you will see kind of where your seller would be required to have the new disclosure. For those who don't know, home hardening refers to building resistant materials and home features that protect a home from catching fire. We all know in California, this is very important. So some of the requirements is when the property was constructed prior to 2010, the property is located in a high or very high fire hazards severity zone. The property is a residential unit, 1 to 4 unit property, including condominiums and manufactured homes. So you will see that all of the standard exemptions under the TDS law apply. The most common include sales involving probate, REOs, foreclosures, bankruptcies, and other types of trusts. And then we linked it at the bottom. And just so you guys know, when we upload this to our YouTube page, I'll make sure that we include all of the links so that you can go back and reference the ones that we are referencing in the presentation. Next. Okay, so determining whether your property is in a high or very high fire hazard zone. So there are 3 main options for making the determination. 1, view the NHD statement to see if either of the boxes pertaining to the zones have been checked. If either of the boxes are checked, it's safe to presume that the property qualifies and they will need to do the disclosure. And an agent may recommend that the seller fill out the home hardening disclosure. However, this may result in an overbroad disclosure since the box for wildlife area forest risks include not only high and very high severity zones, but also moderate zones. So you just want to make sure that you're reading the NHD. However, it's kind of, when it comes to disclosures, it's always, better safe than sorry. 2, seek the guidance of a reputable NHD reporting company. A representative of the company may be able to point out specific areas of the report, which states which hazard zone that property is located in. And 3 is CAL FIRE has made available fire hazard zone viewers that will allow anyone to input the property address and determine which fire hazard zone it's in. So, and then we'll go ahead and link that as well to the, but you could probably find it just by typing in CAL FIRE as well. So, and then it says, no, buyer and sellers may be provided this link, but agents and brokers are advised against checking the maps or drawing any conclusions. Just remember that it is the seller's and the buyer's responsibility to do their own. So we don't want to point out anything. If you look and you see it, then you have to disclose it. So thanks. Next.
Okay. So next thing we wanted to talk about was good faith deposits. Are they required? So must a buyer give a good faith deposit in a purchase agreement for there to be consideration to making it a binding contract? Well, per this information from CAR, it says no, the buyer's good faith deposit in a real estate purchase agreement has no legal significance. It is not required as consideration for the contract because the purchase agreement is a bilateral contract and the mutual promises of the parties serve as an adequate consideration to make the contract binding and enforceable on both parties. And so we actually state a case here. And then, so under the CAR purchase agreements, if a contract is entered into and the buyer fails to make the good faith deposit as agreed, the seller you can't just simply cancel. Instead, the seller must go through the procedure of issuing a notice to perform and giving the buyer adequate time to perform, and then only then can the seller issue a cancellation. So, and then when you get that cancellation, like we've had people say, well, they didn't put their deposit in, it wasn't a good deal. That's not true, because we've actually had issues where it was conveyed in a phone call that they were going to cancel. So the agent said, okay, they're canceling, we'll just forget about them. Went ahead, put the property back on the market. This is years ago. And then she got into new contract. The first buyer came back and said, wait a minute, we want to buy. So the second agent was livid because she was very experienced, and she's like, how did you guys let this happen? And so you want to make sure that you protect your clients and do the due diligence according to the contract. If you have any questions, reach out to us, because that's why we're here. Next. Okay, and Sarah.
Hi. Okay. So we just wanted to touch base on where you can find real estate resources. And so when you are researching, you're going into contract with someone, if you're trying to find out more information about that broker or that agent, this is where you go. We will make sure to link it. You can just input the name, the company name, the licensee name, the license ID, if you want to make sure that it's valid, things like that, that it's not expired or suspended or anything like that. This is a public DRE access portal, and you can check that information here. So we wanted to provide that information to you guys.
One of the tips, and they don't show it on here, when you put the licensee name, always start with the last name, comma, space, and first name, but because otherwise it's not going to come up correctly on there. But if you have the license number, that's the easiest way. Good job.
Yes.
Okay, so is there any questions or any comments? Anything that you guys want us to touch base on next month? Go ahead and add that in the chat. Yeva, did you want to add anything, or?
Not today. I did want to say thank you everyone for all the participants that are viewing this. Our next webinar, we will start a few minutes later than 9:30, because I know some of you guys were still logging in. Thank you.
All right, and it's recorded, so it's always on YouTube. So very good. Well, thanks.
Yes, we'll be sending out instead of just the regular Zoom follow-up email, we will also be emailing you guys with the copy and a link to the webinar, so that you guys have it, and then you can view all past webinars as well. So
thank you. Have a great day, everyone.